I'm Lucien Greaves, co-founder of and spokesperson for the Satanic Temple. I'm joined here today by DeHaan and Kezhaya, both legal counsel who are working with us or have worked with us on lawsuits put forward by the Satanic Temple. Today we wanted to talk about a lawsuit that's been in process for some time now, just went into appeal. In fact, it was May 7th that we had oral arguments, and it kind of seems to have turned around the perception of this lawsuit, which for us had been an uphill and obviously losing battle for some time, as we were really kind of forthright dismissed in the lower court. The claim wasn't taken seriously. We were completely disregarded by the Boston City Council, where we first took our grievance, and it really didn't seem like we were making any progress. And then when the appeals court oral arguments came through, the judges were really pressing on questions of law that we meant to explore when we brought this topic to the fore. Previously, technicalities were being harped on, and that's when that's something we see that they like to do when they want to ignore our suit and not come down one way or the other. We've dealt with this in the courts before. But before we talk about what happened on the 7th, I feel like we need to give the overall background of this case. And I believe it was 2016 when we first applied to the Boston City Council to give an invocation before one of their city council meetings. We had found out that their city council meetings are often opened with a invocation or prayer, oftentimes from a Christian minister. And we weren't really sure what the process was by which they were accepting speakers and putting prayers on the schedule. But we do know that if they are going to open up a public forum to religious expression, that they need to accept all comers. And we found right away that Boston wasn't willing to do that. At the time, the mayor was then a council member, and she wrote up the denial to us, which stated that the Boston City Council has a non-discriminatory invitation-only policy when having speakers come to deliver these invocations. Of course, that seems paradoxical to us. It doesn't make sense that you can call an invitation-only policy non-discriminatory. It's the very definition of discriminatory. While we were in the process of filing suit originally, Boston decided of its own free will, under Michelle Wu, to give up on a pay for pray policy, as we dubbed it, which it turns out that the people delivering these prayers and invocations were not only just chosen as friends of council members to give these public invocations, but they were getting paid to do so. I'm still unaware of how much they were getting paid, but that whole process seemed wildly and radically inappropriate. So we brought a lawsuit against the city of Boston, and initially it was very clear that the court was against us, that the judge really did not want to hear our case and really didn't want to take us seriously, and was not really exploring these claims in any professional or judicious manner. And to that end, we weren't allowed to depose even Michelle Wu, who had written as I said, she had written the denial letter that stated that we weren't allowed to come give an invocation at all. And she was claimed to be too high-ranking a public official, too important to undergo this kind of tedium of having to answer questions for her actions, which also seemed wildly inappropriate. And Boston, the city's counselors, defaulted twice during this case, and at least in one case didn't even ask for an extension, meaning they ran past a deadline and defaulted on the case essentially, but the judge gave them a pass, just allowed them to have an extension without explanation, whereas we were forced to explain ourselves on one of our motions within 24 hours. So I think you could see how very tilted this whole thing was. And it wasn't a surprise to us at the point where the claim was kind of disregarded and thrown away and dismissed by the lower court judge. But then when we took it into appeal, and then legal analysts were commenting on it, they've all but called the case for us already, given how the judges were interrogating the rationale of our opposition and the opposition's just flagrant failure to answer to these questions, and how salient the questions of law are that we do bring up, and how it would be very difficult, we think at this point, and many think it would be at this point, for the court to rule against us having those kinds of oral arguments on record. For a more detailed summary, I'll defer to Matt because he's been the legal counsel working on this all along, but I'm sure you have more to say about the treatment we got in the lower court and potentially the ramifications of that. And if you feel that we are on the track to seeing some kind of justice and more of a discriminating deliberation through the appeals court.